Marcel White, former committee member of Family Life International and still fully sympathetic, of course, will be chairing, and this morning's speaker is Michael McAuley. I have the honour of introducing him this morning. I just wanted to talk about the wonderful aspect of these conferences is the fact that we can meet people working in professions where there is a dearth of serious practicing Catholics. And if you notice in your very colourful and symmetrical brochures for this conference, immediately under each speaker's name is their professional state in life. So it's obviously considered important enough to put immediately below their name. And you've got a bishop, and you've got several priests, a religious, a school teacher, a psychologist, and perhaps most counterintuitively, a barrister as well. Now, this is very consoling for those of us who are either in these professions or who aspire to perhaps make a living from one of the professions that our speakers are working in. And the wonderful part about these conferences, for me, as a person who's just been admitted to be a solicitor recently, is that we have somebody like Michael McAuley, who is a barrister of standing in New South Wales, who has gone before us and who is retaining his Christian faith whilst working in a profession which has largely abandoned the sense of morality that used to accompany being called to the bar. Now, I went to Melbourne University Law School, and Melbourne University has a peculiar Latin motto. I'm glad they haven't translated it to English. They haven't put it in the vernacular. It's still on the crest in Latin, and the phrase on the Melbourne University crest is "Postera crescem laude," which is translated to "Later I shall grow by praise," which I think is kind of appropriate for the University of Melbourne. It's got that right mix of egoism and self-centeredness, you know, because I'm at university here, later I shall grow by praise. Having attended Melbourne University Law School, I thought a more appropriate phrase for their emblem would have been "Spes vos relinquam ad intrantibus hic," which loosely translates to "All ye who enter here abandon all hope." That would have been a more appropriate phrase for the Melbourne University Law School crest. And the reason I love conferences like this is that young solicitors, young doctors, people aspiring to enter the seminary and become priests or religious, we have these models who have gone before us, who are diligently working in their profession whilst always having reference to a Christian conscience and their Catholic life. And Michael, who has been a barrister for 25 years and a Bachelor of Arts and a Bachelor of Laws from the University of Sydney, and as well as a Master of Bioethics from the John Paul II Institute of Marriage and Family, is precisely this kind of person who has been labouring in the vineyard as a lawyer and a barrister, and as a serious Catholic. He is like a lamp unto my feet as a young solicitor, and I also want to commend all of the other people who have spoken at this conference who are diligently working their professions as well. So I have the great honour of introducing Michael, who will now be speaking on euthanasia, the perspective of John Finnis, and a round of applause for Michael, everybody.
Well, thank you, Marcel. You're far too flattering, but when Paul Hanrahan rang me and asked me whether I'd talk, I said to myself, well, there'll be 10 or 15 people here, and that'll be about it. And then someone rang me last week and probably checking that I was still alive and I was coming, and they said, oh, you know, we've got 500 people at the conference, and I could have fallen over. Anyway, you'll see is what's being handed around is a handout which I won't follow precisely, but which will help you follow what I have to say. Now, I'm going to approach the question of euthanasia from a very specific viewpoint. The whole question of euthanasia is something that you could write books, if not encyclopedias, about. So I'm just taking a little peep at it. That's all I'm doing. Now, the first point I want to make is that the question of euthanasia is about individual people. Just at the moment, my 87-year-old father is in hospital. He's got a mild case of pneumonia. We had to talk him into going to hospital. He was reluctant to go. He's got a morbid suspicion of doctors, very well-founded suspicion of doctors, I might say, in hospitals, and to get him to go to hospital requires considerable persuasion. Anyway, we did. But you could imagine if there were a euthanasia law in place, and I said, "Dad, look, I want you to go to hospital." You know, I mean, he's not silly. He might be 87, but he's not silly. And he'd immediately be thinking suspiciously both about me, the hospital, and the doctors, much more suspiciously than otherwise. Well, the euthanasia proposal generally relates to people who are old. The question, of course, is who is old? I consider myself very young, but others consider myself old. It also relates to people who are sick. We all have sickness at various points in our lives, some more than others. We will ultimately all be terminally ill, but what is a terminal illness? Thirdly, the euthanasia proposal relates to disability, but if you look around the room, we've all got disabilities of some sort, greater or lesser. Some more visible, some less visible. So what exactly is a disability? And the fourth area is, of course, the question of choice. I may say I want to be euthanized. What are the circumstances? Is that expression of choice a real choice? Is it something that is genuinely held, or is it as a result of being bullied and coerced, or is it as a result of some illness? Now, I've set out in the paper a copy of Section 18 of the Crimes Act. I'm not going to read it to you, but you can have a quick look through it. But if there is to be an amendment of the law to legalise euthanasia, there's going to have to be an amendment of Section 18 of the Crimes Act. Now, in New South Wales, the Crimes Act follows a certain form. It's broadly the same in most states, and it derives from English legislation. So there's a long history. But as Marcel could tell you, if one looks at that section, or indeed just about any other offence in the Crimes Act, there are three important points which come out more or less clearly. The first thing is, and Marcel's an expert on this, being a Latin scholar, there must be a mens rea. There must be a guilty intention. If I'm driving back to the airport and someone runs in front of the car and they run at such an angle that I just don't see them, and all of a sudden they're there, I may kill the person, but there's no guilty intention. So the first thing is, for a criminal act, there must be a guilty intention. The second thing is, there must be an actus reus. There must be some action which is guilty, which is intended to inflict some harm on a person. We recently had a party at our place. One of the people who came to the party, an elderly man with a good sense of humour, unfortunately had a heart attack. In the course of that, trying to revive him, someone broke his sternum. Okay, now that was a perfectly legitimate thing to do in the circumstances. In different circumstances it would have been a gross assault, but in the circumstances it was perfectly okay. There was no mens rea, there was no actus reus. So one needs to look beyond the mere physical act. The third thing, and in third place, are the circumstances. And you'll see that if you go over the page to the top of page 3, no punishment or forfeiture shall be incurred by any person who kills another by misfortune only. So the law recognises, the law is balanced, it recognises that these things are often need to be looked at with some care. Now, so what I'm going to suggest to you is that the view of wrongful killing, which is in the New South Wales Crimes Act, but which is in equivalent legislation all around the Western world, is a reflection of a deeper view. And if we can go back roughly about 2,500 years to the Greek philosopher Socrates. Now there's always a bit of controversy about precisely who Socrates was. If you look at him through the eyes of Aristophanes, he was an idiot. If you look at him through the eyes of Aristotle, well, he's observed much more coolly. But I'm going to just very briefly read to you a couple of things that Socrates said at his trial. The man who is worth anything has only one thing to consider in performing an action, that is whether he acts rightly or wrongly, like a good man or bad. So Socrates is focusing, in the same way as the Crimes Act, on what one does, and he focuses on whether an action is right or wrong, good or evil. And then a bit later he refers to a period in the history of Athens after the Peloponnesian War when the Spartans had the upper hand and they were running the show, but they were trying to get the locals involved. And he says this: when the oligarchy came to power, the 30 commissioners, they were the hirelings of the Spartans, in their turn summoned me and 4 others to the round chamber and instructed us to go and fetch Leon of Salamis from his home for execution, unjustly. This was of course only one of many instances in which they issued such instructions, their object being to implicate as many as possible in their wickedness. On this occasion, however, I made it clear, not by my words but my actions, that death did not matter to me at all, if that is too strong an expression, but that it mattered all the world to me that I should do nothing wrong or wicked. Powerful as it was, that government did not terrify me into doing a wrong action. When we went out of the round chamber, the other 4 went off to Salamis and arrested Leon, and I went home. I should probably have been put to death for this if the government had not fallen soon afterwards. There are plenty of people who will testify to these statements. So the idea behind the Crimes Act that one should not do wrong, and you go through the Crimes Act, there are literally hundreds of offences, you know. They don't express it in the sense, they don't say don't steal, don't murder, they say if you do this, you know, 20 years in jail, 10 years in jail, 5 years in jail, but it's the same sense. That very concept is the same concept that Socrates was expressing at his trial, that one should not do wrong. And then he goes on to say this after he was wrongly convicted. But I suggest, gentlemen, that the difficulty is not so much to escape death. The real difficulty is to escape from doing wrong, which is far more fleet of foot. In this present instance, I, the slow old man, have been overtaken by the slower of the 2, death. But my accusers, who are clever and quick, have been overtaken by the faster, by iniquity. When I leave this court, I shall go away condemned by you to death, but they will go away convicted by truth herself of depravity and wickedness. So here we have this idea of not doing wrong. Now, again, when Socrates is in prison and his friends are encouraging him to escape, he looks at the proposal in terms of doing wrong, and he says, do we say that one must never willingly do wrong, or does it depend on circumstances? Is it true, as we have often agreed before, that there is no sense in which wrongdoing is good or honourable? Or have we jettisoned all our former convictions in these last few days? Surely the truth is just what we have always said. Whatever the popular view is, and whether the alternative is pleasanter than the present one or even harder to bear, the fact remains that to do wrong is in every sense bad and dishonourable for the person who does it. Is that our view or not? Then in no circumstances must one do wrong. In that case, one must not even do wrong when one is wronged, which most people regard as the natural course. So, in other words, there's a view around popularly, of course, that everything depends on the circumstances, and sometimes it may be necessary to do nasty things, you know, to kill somebody or to kidnap somebody, but Socrates is putting a different view, a view that one must never do wrong. That doesn't mean that one doesn't take into account the circumstances, but ultimately there are some things that must never be done. Now, the Crimes Act basically, and similar legislation in other states, has that concept. Section 83 of the Crimes Act, which is set out I think on page 5, sets out the principal provision in relation to abortion. Now, those of you who are of simple minds may read that section 83 and think it's pretty clear. Whoever unlawfully administers to or causes to be taken by any woman, whether with child or not, any drug or noxious thing, unlawfully uses any instrument or other means with intent, in such cases to procure a miscarriage, which is another way of saying an abortion, shall be liable to be for imprisonment. So, on the face of things, section 83 of the Crimes Act seems to say that procured abortion is wrong. It's subject to a criminal penalty. It obviously involves the question of intent, mens rea, obviously involves the question of the actus reus, the guilty act. So it all seems straightforward. And of course that section has generated a lot of discussion within pro-life movements. However, if one goes to the decision of Judge Levine in Wald's case in 1971. Now, the Sunday newspapers refer to the Levine ruling and the Mahenut ruling as if there's some sort of God-given thing, something like Moses and the mountain. But let me assure you, a district court judge or a county court judge in Victoria is a very lowly creature. And can I tell you this from my extensive experience of New South Wales District Court judges? They are like other human beings. They are drunks, they are unfaithful to their wives, they are nuts, and sometimes they're good and honest people. But just because some lowly judge in the district court says something, don't bow down. Just think about it. Anyway, the Sunday newspapers, with rare obsequiousness, to refer characteristically to the Levine ruling. This is a decision of a single judge. He said that abortion is lawful, and it's at the bottom of page 5, provided there's an... So in other words, what he does is he takes the word unlawfully. Now, almost certainly, that word unlawfully, which ultimately derives from English legislation, was used as a flourish. Whoever shall unlawfully kill Fred Nile here. That's an outrageous thing to do, to kill Fred Nile. Yeah, absolutely outrageous. So here's the legislator saying, look, don't go and kill Fred Nile or any other innocent person, but above all Fred Nile. But so it almost certainly it's a flourish, a Victorian flourish. But Judge Levine didn't see it that way. He said, oh well, there may be therefore lawful or unlawful abortions, and he brought in the concept of necessity. Now, by the way, I should tell you about a famous case. Marcel will tell me the name of it in a sec. There were 3 men in a boat and a cabin boy out in the Indian Ocean, about 2,000 miles from land at the end of the 19th century, and they had little hope of survival, and they hadn't eaten much for a long time, and they hadn't drunk much for a long time, and they felt pretty crook. And the cabin boy was particularly emaciated, and he looked like he was about to die. And 2 of the men started looking at the cabin boy and saying he'd make a fine feed. And this was a situation of enormous desperation. Your heart would go out to these men. 2 of the men knocked the cabin boy in the head and ate him. Well, strangely enough, a ship came along and picked them up and then took them back to England. They were put on trial for murder. And there's a wonderful decision. They were found guilty of murder, and there was a wonderful decision by a judge where he says, look, if I had been in that boat with a cabin boy, I can't say I wouldn't have done the same thing. You know, let me not sit in judgment on these people, but let me on the other hand say the wrongful killing of the cabin boy is still wrongful. So on the one hand, he exercised clemency by understanding the situation, but he wasn't going to tell any lies. And eventually they were sentenced to death, but I'm pleased to say the Queen Victoria commuted the sentence and they were out. And then that was a way of taking into account the circumstances. Anyway, if I'm bitten by a brown snake and someone races me off to Albury Hospital and exceeds the speed limit, that's the basis for a defence of necessity. That's reasonable, and if someone's charged with exceeding the speed limit, well, some sensible judge will let them off. Anyway, you see there Judge Levine's decision in relation to abortion. Now, it seems to me that is a very good example of utilitarian reasoning, because what it does, and has everyone got a copy of the paper? Yeah. Okay, well, I won't bother reading out too much, but what it does, it effectively disregards the value of the life of the child, which is incommensurable, creates a rule which seems to imply that there are huge risks in the woman and the mother having the baby, and that of course has been the basis for abortion on demand. And it involves a number of problems about it. The first thing is it disregards the life of the unborn child. Secondly, it assumes an ability to sort of weigh it all up and measure the question of having an abortion. It narrows the focus, so it focuses on the health of the mother. Now, we of course know that the great majority of abortions in Australia are done on the grounds of mental health, and the vast majority of women who have abortions don't seek psychiatric treatment. There's no psychiatric referral, and the reason is because the concept of having an abortion generally for psychiatric reasons is a sham, and as I understand it, there's absolutely no medical evidence whatsoever, no scientific evidence whatsoever that abortion cures mental illness. None. But that's the basis of this ridiculous rule, the Levine ruling, what's in Victoria called the Mahennet ruling. It's silly. It assumes that you can look into the future, and you'll see that Justice Kirby, who in CES and super clinics probably stated what is the law. I don't say it should be the law, but probably what would be generally regarded as the law. He said the danger may not merely be an existing danger, but at some stage in the future. So if this sort of approach, the Levine, the Kirby, the Mahennet approach to abortion law were applied generally, no one would ever be convicted of anything. Because, and I was originally going to commence this talk by raising this question, and I decided not to because I thought that there'd be people who'd tear me from limb to limb. But I was going to raise this issue. Let's assume I am thinking of killing my grandmother, and I write down a list of all the reasons why I should kill my grandmother. There might be good reasons. She's a nuisance around the place, I'll inherit the money, I'll be able to send my youngest daughter to university and she'll become a doctor and she'll do wonderful good for babies in Africa. You can think of millions of reasons why you should kill your grandmother. There are lots of reasons. I mean, you could also think of reasons why you shouldn't. But see, that's the whole point of utilitarian reasoning, and that's why anyone who's running a criminal law system is never going to accept utilitarian reasoning except Judge Levine in relation to abortion. Because no one would ever be convicted. Because I've acted for all sorts of people. I mean, as Marcel knows, if you pay me, I will appear for you generally. And that everyone's got a reason for doing things. But that utilitarian approach is not an approach which the criminal law generally accepts, except in relation to abortion. John Stuart Mill. Now, I understand there are a few people here who may homeschool their children. Can I suggest to you that John Stuart Mill is an exemplar of someone who was homeschooled? Oh, dear. John Stuart Mill could speak Greek, I understand, at the age of about 5. He was brilliant. He was a wonderfully intelligent person, and he's a great tribute to homeschooling. On the other hand, he got a few things wrong. Now, he was also a Member of Parliament. He was a failed Member of Parliament. He only lasted for about 3 years, but he wrote a number of books on liberty, utilitarianism, considerations in representative government, subjection of women. Now, if John Young were here, he'd tell me that even in John Stuart Mill there are some good things, and there are. But he certainly was seriously wrong in relation to utilitarianism. But of course, his ideas are very, very significant at the present time. And they're part of popular parlance. You read them in the media. If you go to an economics lecture, you're almost certainly going to read that. If you go enrol yourself in a Master of Business Administration, you'll be exposed to John Stuart Mill, even though no one actually refers to him by name. And it's the concept that you can commensurate things, just in the way I've given the example, should I kill my grandmother? That's the question. So I'm going to look at this question of euthanasia in a particular way. You could look at it from the point of view of individualism, the concept that we're all individuals, we're autonomous, basically we're single units. You could look at it that way. We could look at it from the point of view of freedom. Is freedom just the concept, I do whatever I want, or does freedom involve the good? You know, can one be free to eat poison? You know, that obviously can't be the case. One could look at it in terms of historical experience in the Netherlands, what's happened with euthanasia. One could also go through, I could absolutely bore you to death by looking at some euthanasia legislation, or you could look at it from the point of view of Peter Singer. Now, I'm proposing to look at it from the point of view of John Finnis. Now, if John Finnis were here, he's a wonderful person to read, he's a wonderful person to listen to, but I confess he's hard work, and I'm hoping to make him a bit easier work without distorting what he has to say. He was a South Australian lawyer. He published in 1980 a famous book, Natural Law and Natural Rights. Last year he did a second edition of that book. He's published 5 volumes of collected essays, which are all published by Oxford University Press. I would urge you to go and spend the $500 or $600 to buy those books. But they're hard work. You're not going to be able to read them the way you read a John Grisham novel or Agatha Christie. Now, he's part of a school of philosophers who are called the new natural law theorists. Now, when you listen to John Finnis, it's like going into a new world, because he starts talking to Plato and Aristotle and Dworkin and John Rawls and all these people, David Hume, Jeremy Bentham and so on. And so he engages in a dialogue. Now that's one of the great strengths of his approach. In other words, he is at home in our Western tradition. The other strength, and I think it's a very important strength for anyone who engages in public debate, is that he is respectful to his opponents. Now, today happens to be the feast day of St. Thomas Aquinas. If ever there's anyone who's respectful to his opponents, it's St. Thomas Aquinas. He puts their arguments against his position. He puts them better and more fairly than they could put them themselves. So he's not the man who talks over you. St. Thomas Aquinas, you could imagine if he were being interviewed on TV and he were being asked whether God exists, he'd sit there quietly and let the other person talk, and then he'd respond. Anyway, now John Finnis sits very firmly in a tradition of thought, and his the great thinkers who've influenced him are Plato, Aristotle and St. Thomas Aquinas, but many others. Now what he says is about law, that law is about human beings. Now you might think that is a very elementary proposition, but I'd suggest you go to any of the major law firms in Sydney or Melbourne or Perth and you'd find no one thinks that. Or you go to the taxation department or the people who act for against the taxation department, no one thinks that. They've lost the sense of it. But ultimately law is about human beings and about their rights and so on. And he says, Finnis's argument is that there are various aspects of human beings which are good. Now, he expresses that in various ways. You'll see at page 8, I've set out some of the goods of human beings. There's life, there's knowledge, there's friendship, there's truth, there's practical reasonableness, there's religion. And what he's saying is it's impossible to evaluate or establish some hierarchy, and this is where there's a controversy, as to these goods. But, you know, should I prefer friendship or beauty? I went for a walk this morning and I walked around across down to the Victorian border, and I could have sat in my room and prepared this talk, but I chose not to. I thought I'd go for a walk instead. Which was the better thing to do? Well, there are arguments back and forth. you know, looking at the beauty of the water and so on was a great thing. Enhancing my physical fitness by doing a bit of a walk and enhancing my life was a good thing. Preparing this talk, well, probably get done anyway. So these things ultimately cannot be evaluated, but they commensurated, but they are all equally good. You know, friendship is good, appreciation of beauty is good, skillful work is good, playing sport is good, life is good. And we must respect them, and we all make different choices as to what particular good we pursue. Now, the second thing Finnis does, and you have a look at page 9, is he sets out a series of basic requirements of what he calls practical reasonableness. And I won't go through them all, but he suggests a coherent plan of life. I'm a lawyer. You know, if I go off and decide that I'm going to play lawn bowls all day, well, and then the next day I'll say I'll be a lawyer, and the next day I'll be a fisherman, well, I'll achieve nothing. I need a coherent plan of life. Similarly, no arbitrary preferences amongst persons. You've heard of the golden rule, do unto others as you would have done unto yourself. That is not a specifically Christian concept. Christ said it, but you'll find it in all the major religions. Put yourself in the perspective of the other person. If what you're doing to the other person you wouldn't want done to yourself, think again. That's the concept. What would you appreciate if you were a boat person? Assume that you were out in the middle of the sea between Australia and Indonesia, and you eventually landed in the north of Western Australia. What would you want done to you? Put yourself in the other person's shoes. It's just a way of thinking about things. It's not an ultimate determinant of particular action. Detachment and commitment. On Monday, I'm up in the Court of Criminal Appeal. I'm working in a case, I'm appearing in a case where I've been appearing and preparing this case for the last 3 years. If I lose the case, this man is going to go to jail for a long, long time. I could win the case, I could lose the case. I might be able to convince the judges, I might not. Who knows? If I lose the case on Monday, what do I go race off to the gap and jump off the gap? No, of course, I just pick up the next case. Do I prepare the case properly? Of course I prepare the case properly. I've got an obligation to my client to do the best I can for him. So I've got to be on the one hand detached, but on the other hand committed. We'll come back to the limited relevance of consequences and respect for every basic value in every act, the requirement of the common good and following one's conscience. Now, Finnis considers the question of whether pleasure is the point of it all. It's obviously not. I mean, we have a pleasure in eating, but the purpose of eating is not for the pleasure, it's for the survival of us and perhaps talking to other people. Now, but come back to these two really significant matters. The limited relevance of consequences. Consequences are relevant. But if I kill my grandmother, the most obvious thing I am doing is killing my grandmother. If, on the other hand, I'm trying to treat her by giving her tablets appropriately, and the tablets relieve the pain, but unfortunately foreshorten her life, but I have no intention of shortening her life. I'm simply providing her with the medication as prescribed for the purpose of relieving her pain. That is a completely different question. So one does look at consequences, but one must, according to Finnis, put oneself in the position of the person who's performing the act and say to oneself, what is that person seeking to do? And one must go beyond the physical act. That's effectively Finnis's point. Now, because I'm proceeding slowly, you look at cost-benefit analysis. Should I live in Albury or should I live in Sydney? You could sort of weigh up all the pros and cons. Should I buy a Mercedes-Benz or should I buy a utility? You can obviously, in a rough sort of way, weigh these things up. You know, if I go into hospital to have an operation, these days the doctor will say, look, there are the following 50,000 adverse consequences that might occur, and there are all these percentage prospects, and in a certain sense you can sort of weigh it up. That's true. Finnis accepts that proposition that in a certain sense you can weigh up things, but you can't, he says, basic human goods. And he accepts, for instance, it's reasonable to prefer the good of humans to animals, reasonable to prefer human life to property. You know, a fireman goes to a fire, there's a child inside a burning house, does he say, oh, I mustn't break the door? You know, I have a house down at Jinder. My next door neighbour, the water in the roof flooded, the pipes froze, and he broke into the house to turn off the water. And he apologised for breaking one of the windows. Well, yeah, it's ridiculous. Yeah, I mean, there might have been someone in the house. It was great that he broke the window, got into the... Obviously, some commensuration is possible, but the difficulty with utilitarianism as an approach is it doesn't explain whether you should have regard to yourself or to... it doesn't establish any criterion by which you can decide how much good is required. Look, with Fred Nile over here, so I can really make his life absolutely wonderful by making the rest of your lives miserable. Okay, so I can give one person 1,000 units of happiness by just making your lives, you know, leaving you with 1 unit. Is that reasonable? Of course it's not. The third problem with utilitarianism is typically when people use this form of reasoning, my clients, why did you do this client did? They'll always have a reason. They'll always have an excuse. And what they do is they block out certain aspects of reality. That's what we all do. You know, the fact of the matter is when I go to the doctor, he says I'm too fat. I eat too much. I don't do enough exercise. Do I want to hear that? No. That's why I don't go to the doctor very often. Another problem about utilitarianism is there are an infinite number of choices one can make. Absolutely infinite. At some stage, we all make commitments. You know, I'm married to children. After them, I have to have regard to my grandchildren and so on. The other problem, of course, is the innumerable consequences of any action. I don't know what the consequences of me coming down to Albury will be. There are an infinite number of consequences that might occur. Patrick Lee wrote a wonderful book, American Philosopher on Abortion, and he pointed out that, hang on, when you procure an abortion, that child, in Aristotle, that child might have been a Marconi. Who knows what that child, what wonderful things the child might have done. Might have, yes, absolutely. So, has anyone taken that into account? The fact of the matter is, it would be impossible, it would be a burden which would be impossible for us if we had to foresee all the possible consequences of our action. But what we can do is look at what one is doing. One can certainly do that. Now, the second aspect of Finnis's thought that I want to emphasise is, he says, in every act you must respect you must respect every basic good. So you can't act against basic goods. Now, Bill tells me I'm going too slowly, so I'll hurry up. The there's a concept, which I think is a good concept, of absolute rights. Yeah, there are some things one should never do. Now, the problem with utilitarianism is if you are a genuine utilitarian, there is nothing that you would never do. There is no act that should not be done. And that's something that utilitarians need to face up to. Now, very quickly, if you look at page 12, but what is it to do an act? According to Finnis, human acts are to be individuated primarily in terms of what we call intention. Fundamentally, a human act is that which is decided upon or chosen, and its primary proper description is what is chosen. A human action is to be characterised in the way it was characterised in the conclusion to the relevant train of practical reason by the person who chose to do it. Intention, he says, is a tough, sophisticated and serviceable concept because it picks out the central realities of deliberate means and ends in a plan or proposal for action. Alternative proposals is what is meant by intention. What one intends is what one chooses. Included in one's intention is everything which is part of one's plan. So that's what an intention is. So if I decide to murder my grandmother, let me not colour it by saying I'm trying to help her go to heaven. Okay? No doubt she will go to heaven. But that is not my intention. Yeah, let's be realistic about it. When I put the pillow over her head and hold it firmly down, I'm not trying to make her go to heaven. What I intend to do is to kill her. That's my intention. That's why I'm guilty of murder. That's why I've got mens rea and actus reus. Of course, Judge Levine and Judge Kirby and Judge Mahennet would say, oh, you have to have a look at all the circumstances if they were consistent. Of course they wouldn't say that at all because their thought is basically flawed. And that's the problem with utilitarian reasoning. It's not so wrong, it's simply a flawed method of reasoning. It won't work. It's unrealistic. Now, it's in this sense that one can look at John Finnis on euthanasia. Now, I've just about finished my time, but and I've barely got to euthanasia. Anyway, John Finnis defines the central case of euthanasia on page 13 as the adopting or carrying out of a proposal that as part of the medical care being given to someone that his life be terminated in the ground that it be better that if that were done. Now, it's not a question of whether it's a positive act or an omission. Let's be real, be clear about that. You can commit murder by omission. If I don't feed my children intending to kill them, it's just as much murder as if I cut their throats. It's the same thing. The central concept in a wrongful act or a criminal act is the wrongful deed done with a wrongful intention. So, and that's an important point because the proponents of euthanasia will inevitably try and confuse the issue. Now, you can read what I say about intention there. Finnis rejects the concept of dualism. Now, I've heard many people talk about dualism, and some people think it's about sword fighting, but it's D-U-A-L-I-S-M. Now, last night I had a really good night's sleep. Now, during my sleep I thought about nothing. As far as I'm aware, I just was asleep. I didn't dream about anything, I was just asleep. Now, if someone had crept into my room and saw me there sleeping, look, Michael McAuley's gone. The brain's not working, he's just lying there. You know, he's useless. He's not achieving anything. You know, he's not thinking, he's not rational, blah, blah, blah. So if you're a dualist, that's what you'll say. Last night I was gone. I woke up this morning about a bit after 6 and I was alive again. But of course that's not reality. We all know common sense. When a baby is born or a baby is conceived, there is a new human being, a person. That child is limited in what the child can do at that stage, just as I'm limited in what I do when I'm asleep. Or if I become, if I develop Alzheimer's disease, well, I'm limited, but I don't cease to be. And if, for instance, I lose one of my legs because of some medical problem, well, I've lost my leg. It's not my body has lost its leg, I've lost my leg. In some way I'm disabled, but I'm still there. Now that's essentially what Finnis's point in relation to dualism. Another point he makes in relation to euthanasia, the significance, just coming back to the dualism point, the significance of that is, of course, he says, well, yeah, if you've got Alzheimer's disease, the proponents of euthanasia will say, well, you're no longer there. You know, you've gone. Well, yeah, my mother, she died a couple of years ago, but she, in 2001, she had a stroke, and after that, mentally she wasn't all that crash hot, but she provided us with a lot of enjoyment by her bizarre behaviour, which I've inherited, I might say. And, you know, at her best, she would have been absolutely mortified about some of the things that she said. And her grandchildren couldn't believe it, because she became like one of the grandchildren. Was she gone? No, I reckon she was more there than ever. Anyway, that's why, if you're engaging in this euthanasia debate, don't buy the slogans. You know, the word vegetable, it is demeaning. Do not buy it. Now, many years ago there was a lot of argument about victimless crimes, and it was suggested that there were certain things certain criminal acts which are victimless, and one of the victimless crimes was suggested was suicide. And we needn't go there, but Finnis's point in relation to euthanasia is it's not a private act. If I ask a doctor to kill me, that is not a private act. It affects the doctor, it affects the hospital, it has all sorts of impact. If I decide I want to commit suicide, let me assure you it is not a private act, because I act for police officers. I regularly act for crime scene officers. Now, for those who are aficionados of Agatha Christie, let me assure you that when someone dies, there's not a fine little trickle of blood coming out of their right temple. You know, if you're a crime scene officer and you go to a scene and you've got to work out whether it's a murder or a suicide, you will typically you will come away from that crime scene distraught. And anyone who suggests that, you know, a suicide is a mere private act, they need their head read. And similarly, euthanasia cannot be a private act. Now, another point that Finnis makes is what he calls the imminent effect of wrongdoing. Won't be long. Just sit down, Marcel. Sit down, Marcel.
I'm achieved my purpose.
Yeah, sit down, Marcel. I'm going to finish this. Look.
Don't stop me, Marcel.
Yeah, you can't stop me. When I murder my grandmother, the impact is not merely on my grandmother. It's on me. I become a different sort of person. I become a murderer. And so my whole world has changed. When our Lord commenced his public life, he the very first thing he said was to repent. Why did he say that? Because he realised that committing wrongful acts causes one to be changed as a person, and one has to change back. The Church is very wise about that. Now, obviously, if you introduce euthanasia, the whole approach to the medical profession will change. Obviously, if you introduce euthanasia, Dad, when he's thinking about whether he should go to hospital because he's got pneumonia, will start thinking again. And he'll look at me, and he'll look at his other children, look at the nurses, look at the hospital, with sensibly critical eyes. Sensibly critical eyes. And so what is being proposed with euthanasia is really a massive change. This is a civilisational change. One thing Finnis doesn't do when he looks at the euthanasia question, he doesn't consider the problem of adverse consequences. And let me just, so this is a minor criticism of Finnis. I, as a lawyer, make a certain amount of money each year by suing doctors and hospitals. And I can tell you it is a wonderful area to be in, because there's plenty of money to be made and it's relatively easy money. There are a huge number of adverse consequences, that's what they call it, in hospitals. And there are a huge number of adverse consequences which involve negligence by either doctors or hospitals. And they're often covered up. So the concept of giving this sort of power to doctors is truly frightening, because if one is familiar with the medical negligence scene, one would be terrified. The other difficulty, and Finnis does to some extent refer to this, is the plasticity of medical opinion. I can assure you, I can get a medical opinion from some doctor for just about any proposition known to man. Most people think doctors are very serious, objective, sensible people. Let me assure you, there are doctors who will support any form of idiocy. So when you have two doctors certifying that a person is freely giving their consent to being knocked off, think carefully. Think carefully, because you can get experts to say anything. There are experts around who've been justifying tobacco companies. Yeah, I mean, a classic example. So anyway, look, that's about all I can say. So effectively, what I'm recommending is that you do read John Finnis. He's a hard read, he's a challenging read, he's a writer whose opinions will be significant for hundreds of years into the future, and he provides you with the intellectual equipment to deal not only with euthanasia but with a whole range of issues. He's not beyond criticism, and I haven't bothered with the critics, but he's well worth reading, and I'd recommend him to you. Thank you.
Thank you, Michael. We'll thank Michael.
He